I'll never forget the day Martha Wilson stood in my law office, tears streaming down her face, a 68-year-old widow clutching a stack of HOA violation notices. The Homeowners Association had fined her $7,500 for a garden fence they claimed violated community standards. Can you believe it? $7,500? For a fence that had been there for 12 years. They're gonna put a lien on my house, she said, her voice breaking. I could lose my home over a fence. As a property attorney with 25 years of experience, I've seen this scenario play out hundreds of times. Ordinary homeowners feeling completely powerless against their HOA boards. But here's the truth they don't want you to know. With the right documentation, you can fight back and win. And that's exactly what Martha did. Just 3 weeks after walking into my office, every single fine was dismissed. The HOA board even issued a written apology. How did she do it? By gathering 7 essential documents that completely changed the power dynamic. Let me break this down for you. Here are the 7 critical documents that can turn the tables on your HOA. I've used these exact strategies to help hundreds of homeowners stand up to HOA bullying and win. Number 1, and trust me, this one is often overlooked, the complete current HOA covenant, conditions, and restrictions. You'd be shocked how many homeowners fight their HOA without having read the full current version of their CC&Rs. This comprehensive document outlines all the rules governing your community. Most people only have the summary version provided at closing, or worse, an outdated copy that doesn't include amendment. Don't make this mistake. Always request the complete updated CC&Rs directly from your HOA. They are legally required to provide them to you. When Martha reviewed her complete CC&Rs, she discovered something that changed everything. The architectural guidelines had been amended in 2015. But guess what? The amendment hadn't followed the proper voting procedure required in the original document. This bombshell meant the new fence restrictions they were trying to enforce weren't even legally binding. Here's what most people miss. The HOA's own rules often contain the very protections they're violating when they target you unfairly. You just need to know where to look. Still with me? Good, because this next document is what saved Martha from financial disaster. Number 2, written HOA board meeting minutes from the last 12 to 24 months. Did you know you have the legal right to access minutes from HOA board meetings? Most homeowners have no idea. These documents are absolute gold mines of information. They can reveal inconsistent enforcement, board member conflicts of interest, or procedural violations, all ammunition in your fight. Request meeting minutes from at least the past year, preferably 2 years. Look closely for discussions about your specific issue or similar violations. Here's where it gets interesting. If the board approved exceptions for other homeowners but denied yours, you've just identified selective enforcement. And that's one of the strongest defenses against HOA actions. In Martha's case, the meeting minutes revealed something shocking. 3 board members had been granted exceptions for similar garden structures in the past year. Talk about a double standard. This became the centerpiece of her defense. One important tip when requesting these minutes, do it in writing. Cite your state's property laws that guarantee your right to these records. If they refuse or delay, document it. Their refusal actually strengthens your position and may violate state law. Number 3, prior written approvals and communications. Never, and I mean never, enter an HOA dispute without gathering every piece of prior written communication about your property. This includes previous approvals, emails, letters, violation notices, inspection reports, everything. Martha had saved an email from the previous HOA president from 2011. It specifically acknowledged her fence and noted it was grandfathered in despite being slightly taller than current standards. This single document completely undermined their entire case against her. Here's something most homeowners don't realize. In many states, even verbal approvals from board members can be binding under certain circumstances. If you received verbal approval, immediately send an email summarizing the conversation. Ask them to correct any misunderstandings. Their failure to contradict your summary, that can sometimes be treated as tacit confirmation. Most people miss this, but you won't after watching this video. Number 4, and this one is powerful, photographic evidence of similar properties. One of the most effective ways to fight selective enforcement is with visual evidence. Take date-stamped photos of similar violations throughout your community that haven't been cited. This creates an undeniable record of inconsistent enforcement. For maximum impact, be methodical. Create a spreadsheet listing each address with similar condition. Note how long the condition has existed. Document whether these properties received violations. Let me tell you what Martha and her neighbor did. They photographed 17 properties with similar garden structures. Not a single one had received a violation notice. And here's the kicker: 3 of them belong to friends or relatives of board members. I'm not making this up. When presenting this evidence, remain factual and unemotional. Simply stating, here are 17 properties with similar conditions that haven't been cited, is far more effective than accusations of favoritism. Are you starting to see how powerful these documents can be? Let's keep going. Number 5, expert opinions and professional assessments. Independent expert opinions provide objective evidence that's hard to dismiss. Depending on your specific dispute, consider getting a licensed home inspector's report or maybe a certified appraiser's opinion on property values. Even a landscaper's professional assessment can make all the difference. These professional opinions shift the argument from subjective disagreement to objective professional standards. The HOA board suddenly can't just say, "We don't like it." They have to counter expert testimony. For Martha, a local landscaping architect provided a written statement that her garden fence complied with general standards for residential properties. He even stated it enhanced rather than detracted from neighborhood aesthetics. Yes, these assessments cost money, but they're typically far less expensive than paying unjustified fines or making unnecessary modifications to your property. Still with me? We're getting to the most powerful documents now. Number 6, state and local laws that supersede HOA rules. Here's a secret the HOA doesn't want you to know. Their covenants cannot override state and local laws, period. Numerous states have passed legislation specifically limiting HOA powers regarding solar panels, political signs, drought-tolerant landscaping, flag displays, home-based businesses, and more. Research your state's property laws and homeowner protection statutes. Print the relevant sections and highlight the applicable portions. In Martha's case, our state had passed an architectural review reasonableness law requiring HOAs to apply standards consistently and reasonably. This statute, combined with her evidence of selective enforcement, formed the legal backbone of her defense. Remember this: when an HOA rule conflicts with state law wins every single time, no matter what your CC&Rs say. And finally, number 7, documentation of procedural violations by the HOA. This is the knockout punch. HOAs must follow their own procedural rules when enforcing covenants. Any deviation from these procedures can invalidate their actions against you. Look for violations such as insufficient notice periods, improper delivery of notices, failure to provide required hearings, incorrect fine calculations, board members voting on matters where they have conflicts of interest. Document the exact procedural requirements from your CC&Rs and compare them with how your case was handled. Note every discrepancy, no matter how small. You won't believe what Martha discovered. The HOA had failed to provide the required 30-day correction period before imposing fines, and the violation notice hadn't been sent via certified mail as required by their own procedures. These procedural errors alone would have been sufficient to dismiss the fines. Now, let's talk about how to use all this powerful information. Once you've gathered these 7 essential documents, organize them into a clear, professional presentation. Create a binder with labeled sections. Begin with a calm, factual cover letter summarizing your position. This is critical. Avoid emotional language or personal attacks, no matter how justified they might feel. Professional, evidence-based communication is far more effective than angry complaints. Martha's presentation began with, "After reviewing the attached documentation, I respectfully request that the board withdraw all fines related to my garden fence." She then listed each piece of evidence clearly and calmly. The result? Complete victory. Every fine withdrawn, a written apology from the board, and a clarification of the grandfather clause in their architectural guidelines. She accomplished this without ever going to court, armed only with the right documentation and the confidence it gave her. Let me share another quick success story. James Peterson used meeting minutes to prove the HOA board had specifically approved swing sets identical to his just months before sending him a violation notice. The board withdrew the violation within 48 hours of receiving his evidence. 48 hours! These successes share a common element: homeowners who appeared prepared, informed, and methodical in their approach. HOA boards often back down when faced with homeowners who clearly understand their rights and have the documentation to support their position. Once you've resolved your current dispute, take these steps to prevent future conflicts. Attend HOA meetings regularly. Keep all communications with the board in writing. Request written approval for any property modifications, even minor ones. Remember, homeowners associations can provide valuable services and protect community standards. The goal isn't to undermine your HOA, but to ensure it operates fairly, consistently, and within its legal authority. As I tell all my clients, in HOA disputes, knowledge truly is power. The board's authority relies partly on homeowners' ignorance of their rights. When you gather these 7 essential documents, you transform from a seemingly powerless homeowner to an informed, formidable advocate for your property rights. Martha still lives in her home of 37 years, garden fence intact. The current HOA board now consults her on bylaw revisions, valuing her attention to detail and procedural knowledge. Whether you're currently facing an HOA dispute or simply want to be prepared, these 7 documents provide the foundation for protecting your rights as a homeowner. Remember Martha's words when she called to thank me after her victory: "I didn't just save my fence, I found my voice." Armed with the right documentation, you can find yours too. If you've ever felt powerless against your HOA, remember, it only takes the right knowledge to shift the power back to you. Now you know exactly what to gather, and if you ever need it, this video will be right here waiting. Share it with a neighbor who might need it too. Together, we can build communities based on fairness rather than fear.